So the fourth ground of appeal is, I call it the sauce for the goose, sauce for the gander. Having got to the end of this exercise, it would have been right and just and fair to declare the ones on which they prevailed and the ones on which we prevailed, and to do it in a schedule. The whole exercise was binary from beginning to end. I don't wish to add anything to what is said in ground 4, which is on page 17 of the core bundle, and what is said in paragraphs 104 to 109 of our skeleton of argument, which is pages 47 and 48 of the same bundle. Subject to that, unless you have any questions for me arising out of anything I said this morning. No?
No, thank you.
Right, thank you. I'll give way to Mr. Holland.
My lords, my lady, we have identified in our skeleton argument certain rows that we have relied upon as exemplifying the errors that my learned leader has addressed you on. And the first of those is in paragraph 70 of our skeleton, which is on page 39 of the core bundle. And this identifies three subsets, three groups, within the context of what has loosely been called targeting, use in the United Kingdom. And I would propose, with the Court's permission, to spend most of my time looking at those three on the basis that they raise the most substantive points, and ones that, in accordance with the decision of the Supreme Court in Amazon, do require a detailed stage-by-stage analysis. But obviously I will do this by reference to the judgment, so that the Court can see the findings that were made, and I will identify the ways in which we say, with respect to the learned judge, erred. Time permitting, I would then propose to show you a handful of examples from the other areas, the 4D and 4H parts of the case. But as I say, I'm proposing to spend most of my time on this. And as you can see, my lords, my lady, in paragraph 70, we've identified A, B, and C, rows E, and there's something brief to add on HH, followed by Q, and finally EE, and similarly something brief to add on FF. Now, as I say, I'm proposing to do this by reference to the judgment, so could I invite the Court to take the judgment in the core bundle behind tab 5. And I'm going to go to the part that addresses, firstly, row P, but just en route, may I invite the Court to take note of paragraph 107 on page 108 of the bundle. The learned judge is noting here in paragraph 107 that he doesn't regard any other issues as suitable to deal with in the abstract, but he identifies in the second line that the fact that the parties devoted time in their oral and written submissions to general discussions of the question of pop-ups. He says he doesn't find it helpful to deal with them in the abstract, but he will consider them in the context of the rows, both so far as they relate to the B exception and in relation to the question of targeting. Of course, that was entirely open to him to do that. We will submit that he actually didn't take into account pop-ups at certain points of his analysis. I will come to that in due course. So could I ask you please to turn on, within the judgment, to paragraph 355, which is on page 165. There is a heading above 355, which, as in our skeleton, addresses rows P and HH, which he deals with together, although he starts with row P. And as he summarises in that paragraph, the complaint in row P is that Merck US promoted jobs available in its organisation throughout the world at jobs.merck.com, which use Merck branding. The jobs advertised included jobs expressed to be located in the UK. He notes quite rightly in paragraph 356 This is alleged to amount to a breach of paragraph 2. That is the only allegation that we're dealing with at this moment. It's only the paragraph 2 breach. He refers at 357 to the evidence given by Mr. Domingo, the Associate Director of Talent Solutions at the first defendant. And he quotes quite a lot of it. May I ask you, please, just to look at a couple of antecedent paragraphs in his statement to put this in context. My lords, my lady, you'll find that in bundle S2. And it's behind tab 25 in that bundle S2. And if you turn over to the second page of the statement, so I'm looking at 716 of the bundle, he explains at paragraphs 6 and 7 that he's an IT specialist, the HR operations team and his team are responsible for overseeing the job websites at jobs.merck.com and jobs.msd.com. So there are two parallel websites for jobs. One is a Merck site and one is an MSD site. And he goes on at paragraph 7 to explain that they're public-facing recruitment sites. The jobs.merck.com website is intended for individuals in the United States and Canada. The jobs.msd.com website is targeted at individuals outside of the United States and Canada. The important point to note is that this is a major change from the position as it existed at the time of trial, when there was only a Merck.com site. There wasn't an equivalent MSD site or a jobs.msd site at the time of trial. And this reflects the approach which we have identified in our skeleton argument of substantial changes that were made in between the first trial and the position as it arises now. And that was explained in the evidence of Ms. Herman, and I'm not going to ask you to look at very much of that, but it is in the same bundle. So while we're here, if I could ask the court to turn over to tab 35. So I'm looking at page 778 of the bundle. This is the witness statement of Ms. Herman, who, as you see from paragraph 1, is the head of corporate communications at the first defendant. And if one turns over to the next page, she says at paragraph 8, following the making of the order, that is the final order that we saw earlier, in this action in August 2022, each of the defendants considered their activities to ensure compliance and, if necessary, made changes to their website. She points out that even before then, some changes had been made by the time we got to the remitted issues decision, and that was addressed in other statements, not in the current bundles. She says in paragraph 9, as she describes below, the first defendant has developed considerably its use of the MSD brand on the internet and social media, and has sought to correct any errors as soon as it's become aware of them. She goes on over the page at the bottom of paragraph 13, the end of paragraph 13, after saying that none of the uses was the result of a deliberate policy choice. She says, the first defendant has sought to develop strong and separate lines of communication under Merck and MSD, which are separate from each other, and has sought to develop websites and social media that allow it to operate in compliance with the order. And she gives examples of, in paragraph 14, the fact that there are now two key websites, Merck.com and MSD.com, parallel sites with similar content, and MSD.com is now a fully developed site, she says at paragraph 15, whereas Mr Justice Norris records that at the time of the trial, MSD simply forwarded to Merck.com. At paragraph 16, she says that they're separate from each other and not integrated. MSD.com contains links to other MSD-branded sites, such as MSD.manuals.com, MSDformothers.com, MSDanimalhealth.com. These sites are also fully developed and part of a comprehensive MSD-branded offering. Again, that was not the position at trial. And in paragraph 20, she gives an indication of the scale. MSD.com now has 59 landing pages, 106 feature stories, and over 12,500 pages in total. Merck.com similarly large. And although I'm not going to ask you to look at them, she goes on in the statement to talk about the training that has been implemented from paragraph 31 onwards, and certain guidelines, paragraph 32 onwards, some of which are reproduced in this statement. The witnesses on behalf of the MSD defendants confirm where they've taken that training, and it is my submission that it is clear from the evidence overhaul that some very substantial steps have been taken to comply with the order, and we've summarised some of those in our skeleton, paragraphs 42 to 52, which you will have seen. As my learned leader pointed out, none of that was referred to in the judgment, and we say that it is important to understand that as the background context. Thank you. I think we can put away S2, and I will revert to the judgment. So I'm back now in the core bundle at page 165. And I was looking at paragraph 357, which, as I noted, referred to the evidence of Mr. Domingo. You've just seen the introductory part of his evidence. He goes on to explain in the parts that are quoted, paragraph 11 there, that once a job is advertised, it is automatically listed on either the Merck or the MSD version. There's a logic built in to do that. Paragraph 12, he explains that we have jobs that can be carried out from more than one location. We call these cross-posted jobs. For these, there's a primary location, and there may also be a secondary location, and it is automatically cross-posted to the relevant websites. So that is the background about cross-posting of jobs. So to summarise the position, there are no jobs in the UK on jobs.merck.com unless there is a US job for which there is an alternative location in the UK. Whereas in contrast, all UK jobs are listed on the jobs.msd.com website, which is the one that is intended for the rest of the world, including the UK. Just moving on in the judgment, we see at 359, he refers to more of Mr. Domingo's statement, which refers to disclaimers, and he notes that parts of it are exhibited at pages 5 to 12 of the exhibit, where you can see more of the website as a whole. I would propose at this time, with the court's permission, to show you what the evidence of the claimants was, so you can actually see what the website looked like. And the convenient way to do that is to start with the evidence of Mr. Day, which is in bundle S1. Behind tab 7. Your Lordships, your Ladyship will have seen many references in the judgment to what is referred to as Day 2, which is the second witness statement of Mr. Day. This is the long statement that was served at the same time as the application, which sets out by reference to the rows in the schedule the various breaches that were alleged and exhibits the relevant materials. And if one goes on to page 225 in the bundle, you will see that there is a heading just below the lower hole punch, advertisement for UK jobs on jobs.merck.com. And at paragraph 84, the complaint is that advertisements for MST jobs, the location of which is the United Kingdom, appear on jobs.merck.com. In addition to the use of Merck in the domain name, the site contains prominent use of Merck in the following logo. It's not denied it contains prominent use of Merck. The reason we say is because this is the US website. Then at paragraph 85, he exhibits screenshots of jobs.merck.com as it appeared on the 5th of October 2021. And that's really the totality of the allegation. Over the page on 86, points about the copyright notice and the who is search are simply directed to who is the relevant defendant. They don't form part of the allegation of what is the improper use of Merck on the site. So you have in 84 and 85 the totality of the allegation. Nothing else is relied on, and Mr Day doesn't explain how either he or Khaled Farah, who took the screenshots, arrived at those websites. They are simply pictures of the websites to look at. There is certainly no suggestion, and quite rightly, is there no suggestion that there are any links from any of the defendants' UK sites that would have taken you there. And to the contrary, the evidence of Ms Herman is that the sites are kept separate. So if I could invite you please to look at the exhibits, which are also in this bundle, you'll see what we are in fact talking about here. It's behind tab 10, and it starts on page 342. And if one goes over to page 343, one sees the relevant website, and one can see from the menu bar or the address bar at the top, we are looking at jobs.merck.com/us/en. So this is the jobs website. There is, under the picture, there is a search bar which one can enter text into. And directly underneath that it says, this site is for residents of the United States, Canada and Puerto Rico. Residents of other markets, please click here. So I should qualify what I said about there not being links between one another. There are express links directing one to the correct site. So if one does click here, one is taken to jobs.msd.com.
Is that underneath the white bit that's on the face of the...
It is, my lady. It's not entirely easy to read. We do have some colour copies. I'm hoping that these are adequate, although if the court would find colour copies of assistance, they can be provided. But yes, there is a large dark grey box directly underneath the picture on page 343, right at the top of which there is a white box with the magnifying glass search logo to the right, where it says search by job title or location. And I'm reading the point directly underneath that. This site is for residents of, and at the end of that, residents of other markets, please click here. And it is that here that will take you to another site, my lady. Now, while we're on page 343, if one looks at the top right, one sees the slider bar, which is shaded at the top. So we're only looking at the very top of this page, which is fine insofar as it goes, but I just draw that to the court's attention. If one turns over to the next page, so page 344, somebody has typed in the words United Kingdom, and one can see that that has then produced, underneath the words United Kingdom, location, United Kingdom, and to the right-hand side the number 3, which indicates there are 3 results. And if we turn over the next page to 345, we can see in the address, the address bar, United Kingdom has been entered as the search words that were typed in. On the right-hand side of the page, underneath the heading Invent with Us, there is another set of wording that reiterates this site is for residents of the United States, Canada and Puerto Rico. Residents of other markets, please click here. And then at the bottom of that page 345 we see the results, which, as indicated by the number 3, shows 3 jobs. Just to put that in context, Ms Herman's evidence is there are 68,000 employees worldwide. So there is a fairly small subset that have cropped up in the United Kingdom. And you can see at the bottom of that page 345, the first job is managing medical writer, and there's a little drop-down box that says jobs available in 4 locations. you go over the next page, please, to 346, you can see that more clearly. So this is just an extension. We scroll down from the page we were on before, so you see the same wording for the managing medical writer. Job available in 4 locations. The first is Durham, North Carolina. There are then 2 possible locations in the United Kingdom, and then another one in Rahway, New Jersey. The same is the case for the Senior Specialist Clinical Supplies Project Manager. That can be performed in 5 locations, the first of which is in the USA, the second is Canada, then Switzerland, then one in the United Kingdom, and then one in the USA. Just before moving on to the next page, you can see at the bottom of the left-hand column there is an About Us paragraph. We are one company, but we operate under 2 different corporate brand names. We are known as Merck & Co. in Kenilworth, New Jersey, USA and United States. That is in the permitted form of wording, so no objection is taken to that. And if you go over the page, you can see it continues, we're known as MSD everywhere else. And over the page on 347, we see finally the last of the jobs available in 6 locations, and indeed 5 of those are in the United States of America. One of the locations which is given as an alternative is the United Kingdom. So that is the totality of the material that is relied upon for the allegation under row P. If I could ask you to put that bundle away for completeness, and I'm sorry to be darting around a bit between bundles, but I would ask you to look, please, in bundle S2, because as I noted earlier, Mr Domingo exhibited some more of that page, the jobs.merck.com, and one sees this in S2 behind tab 26. And if I go on in that exhibit, because he refers to some other materials, the parts that the judge referred to in his judgment start on page 726 of the bundle. So this is having regard to the decision of the Supreme Court in the Amazon case, saying that one does need to look at the website as a whole. Here on page 726 we see the same starting point as in Mr Day's evidence, but over the following pages we see that you can scroll down, as I indicated on 726 at the top right. The slider bar is at the top, and as you go down the page you see there is a lot more material. And I would respectfully submit that a job applicant is quite likely to be interested in the whole of the website, or at least would take it in context. And if one looks through this material, you find repeated disclaimers, such as on page 728. So we once again see in the middle of 728, just above the grey, long grey box, the fact that we're one company but operate under 2 corporate names. And indeed I would point out that above, where it's talking about the organisation, there is the use of dollar signs, the US currency. And if one goes on to page 730, there is a reference on the bottom right hand side to US contingent opportunities. And on page 732, there are various awards given by the likes of Forbes and Fortune and Bloomberg. And finally on page 733, once again, underneath the stars, there is a middle heading, beware of hiring scams, and underneath that, once again, this careers website is intended for residents of the United States, and so on. So that is what the whole site, that whole page actually looked like. While your Lordships and Ladyship are here, could I ask you please just to look at page 736? Because Mr Domingo explains that later on, so I accept not to be taken into account for the purposes of row E, there was a pop-up added, and the court can see that on page 736. So presented in front of the website before one can access it, there is that sign, attention, by continuing you will be directed to a site intended for. So that comes up before you can even get to the website. So again, I think we can put S2 away at least for the time being. So to summarise what that evidence shows in my submission, prior to a visitor to that website themselves entering United Kingdom, those words United Kingdom in the search box, in my submission there is nothing at all on that site to indicate that it is aimed at the United Kingdom. And for anyone looking, there is plenty to indicate that it is not. Now, reverting to the judgment, and I hope I can pick up the rest from the judgment. So I'm back in bundle C, and I'm on, I've just gone on to page 166. So I was showing the court the parts of Mr Domingo's evidence at the top of page 166. Then paragraph 360, that's the pop-up I've just shown you. Mr Domingo explains that a pop-up was subsequently added, which went live on the 28th of October 2021. There's a point in 361 which
also makes the point that geo-blocking was added.
It was, yes, my lord. There was some debate about exactly why that was done below, but it is true. It has now been geo-blocked, yes. 361, we don't need to dwell upon. The point was made that the claimant apparently was doing something similar, but that doesn't matter. And then really the decision comes in 362. The learned judge says that it seems to me that the advertising of jobs in the UK on the Merck branded website was a breach of paragraph 2. And he accepts the submission of the claimant that at the time when the screenshots were taken, the reality was that a person searching for Merck jobs in the UK would have found the jobs.merck website and read what was on offer. Just pausing there, we submit that with respect that is not right. There was no evidence to support that. We accept that the site was accessible. That is not enough. There is no explanation or even suggestion of how a person searching for Merck jobs in the United Kingdom would have found that site. No evidence not only that they would have done or how they would have got there if they had done. It was simply the case that there is a screenshot showing that it is accessible. The evidence, so far as there was evidence, says that there was a separate MSD site for UK jobs and that the defendants sought to keep them separate. And as I've said, there was no suggestion of any links from any UK sites that would have led people to that Merck jobs site. So with respect, we say that that was an error. He then goes on to say that he doesn't think the disclaimer is sufficient, and although he can accept they were cross-posted jobs, I do not see how it can be said that the advertising of jobs on the website, which were described as being located in the UK, can be said not to have been targeted at potential employees. In my submission, my lords, my lady, that is the wrong way round. The judge is focusing simply upon one aspect of the website, not on the website as a whole. It would result in the fact that the advertisement of any job in the UK on any website accessible anywhere in the world would amount to targeting on the basis that it might be of relevance or interest to somebody in the UK. And I submit that is not the approach required by the Amazon case in the Supreme Court. It is focusing on one thing to the exclusion of the site as a whole, and having regard to the fact that there is no evidence of anyone from the UK actually being directed there, and hence no evidence that someone looking for Merck jobs would have found their way there. So that is the submission about what row P, subject to the fact that I would point out that it does appear in my respectful submission to be inconsistent with the approach that he took elsewhere. And so if I could invite you to turn back to paragraph 246 in the judgment. this is dealing with previous rows A, C and D, and this is the Merck COVID research website. There was one error in which there was a link to this website, which he has accepted was inadvertent. And then he goes on at 246 to say that if one puts that erroneous link to one side, one is left with the Merck COVID research website, which was intended for US consumption and sat alongside the MSD COVID research website, which was intended for consumption in the rest of the world, including the UK. So on that basis, the fact that there are two parallel sites in much the same way as there are for the job sites leads him to conclude that there is not targeting. The existence of the parallel sites is, in my submission, a relevant factor. And he goes on at 247 to refer at rows C and D to various clinical trials website. And 3 lines in at 247, he says in the case of rows C and D, the claimant argued that the relevant websites contained information about clinical trials which were taking place on a worldwide basis, including in the UK, and as he points out in this case, there was no equivalent MSD branded website. But again, he says, and there is no challenge to this finding, that that was not targeted at the United Kingdom. So the existence of some UK content or some material of interest to readers in the UK, including
But
clinical
why is that
trials.
inconsistent? In the one case, you've got a job which is expressly for someone, and that's said to expressly to be located in e.g. Pancras Square in London. I don't see the inconsistency.
Well, my submission, my lord, is that the position indicates a focus on one point to the exclusion of the others, and the parallel I'm seeking to draw here is that there is a website for MSD COVID research and Merck COVID research.
That's completely different, because it's just informatory. It's saying, we do clinical trials about COVID, and guess what? We recruit the patient cohorts from all over.
Well, indeed, my lord, one can find in the bundles that one can similarly insert United Kingdom and see information about it. But for that reason, I'm submitting that it is comparable. But the bigger point, my lord, is that we say that it is focusing on one point to the exclusion of others in a way which doesn't represent the required approach under the Amazon decision in the Supreme Court.
Okay.
And we would say, in summary, my lords, my lady, that the defendants are entitled to have a US website using the Merck sign, and they are entitled to list job opportunities there and to tell their US audience that the jobs may alternatively be performed in the United Kingdom or indeed in Switzerland or in anywhere else. That may be an attractive selling point to a potential employee in the USA, and that is not...
Yes, but of course geo-blocking is the answer, isn't it? Which is what you've now done.
Well, my lord, it is an answer, but with respect, the judge was very clear. There was a lot of argument about whether geo-blocking should be required. The judge held it was not required. It was given as an option, and therefore it appeared as a schedule to the order, as one way of complying. There are reasons why the defendants do not wish to geo-block, and they are, in my submission, not required to do so unless and until there is targeting. And the antecedent question is whether there is targeting, which in my submission there is not.
If you do a Google search for Merck jobs, it brings up jobs.merck.com. Now it is now geofenced, so when you click on it, it goes to this website is not available in your country, but presumably that wouldn't have happened before, and you've gone straight to the website. So that's how somebody gets there. They put in Merck jobs, and up comes jobs.merck.com.
Well, my lord, there was no evidence of that at all in front of the court below. It was a submission that that's what might have happened, but it was not investigated, and there was no evidence to that effect as to how it had been arrived at by the claimants. I don't know what the position was at the time. Take your lordship's
It's
point.
hardly rocket science.
No, exactly.
Well, be that as it may, it remains our submission that mere accessibility is not sufficient, and as Mr Justice Jacob, as he was at the time in the Crate and Barrel case, said, when one does a search, one expects all manner of things to be thrown up, and you look at them in order to see whether or not they're of interest and whether they are intended for me. And if they're not, you move on. And in my submission, when one arrives at that website, for the reasons that I've shown you, there is plenty to indicate that it is not for you. It is not intended for residents of the United Kingdom. And in fact, there is a website which is intended for you, to which you are directed elsewhere.
You also get an MSD branded job advertised. Oncology therapy lead, North West Midlands and North Wales, Merck KGaA Inc., Greater London.
Well, my lord, I can't comment on that.
No.
It is,
I appreciate you can't comment on it.
I would point out that Merck KGaA Inc., provided it has a geographic indication, is permissible under the terms of the order. So I can't comment on whether there's a problem there, but there's nothing in principle wrong with saying Merck KGaA Inc. with a geographic limitation. So the only other point on this section is in relation to row HH. The judge's reasoning about this was the same, unsurprisingly. It related to an automated chat bot that popped up. So this is 364 of his judgment on page 167. He deals with it in the same way. We say that the reasons that he gave were wrong for the reasons I've just submitted. The only other point to make is that these screenshots and this row HH was after the pop-up was added that I drew the court's attention to. And in our submission, in circumstances where we had stressed the importance of pop-ups, that was an additional factor that he should have taken into account as operating in the defendant's favour, because that would have popped up irrespective of what journey. And to take my Lord Justice Phillips' point, even if there had been a Google search, a pop-up would have come up to say this is only intended for people in the US, even before you get to the website. And therefore for row HH, that is another factor which we say he should have taken into account. My lords, my lady, I propose to move on to row Q, which is the next of the rows of our skeleton, and conveniently also the next one that he deals with in the judgment. So on page 168 of the bundle, there is a heading, row Q analysis, and as he says at 370, row Q is concerned with safety data sheets. The complaint is that the safety data sheets for products intended to be available to people throughout the world were compiled together and only accessible at the Merck website. That language, only accessible at the Merck website, we say is not entirely correct. It doesn't give the full picture for reasons I'll come on to. And therefore the following sentence, anyone wishing to view the SDS therefore had to access this website, again is not entirely correct. As one sees from 371, this is alleged to be both a breach of paragraph 2 and also paragraph 3. So we have the trademark aspect as well as the contract aspect. He quotes some parts of the witness statement of Ms. Basile. Again, I'm sorry to ask you to do this, but I wonder if I could ask the court to look at an antecedent part of her evidence just to make it clear what these documents are. This is in S2. And it's behind tab 21. So it starts on, I'm looking at page 689. If we go on to the following page, 690, she explains what these documents are at paragraphs 6 and 7. So she says in paragraph 6 she's been asked to explain the use of safety data sheets. She starts with the US and points out that under federal legislation, chemical manufacturers or importers are required to classify the hazards of chemicals which they produce or import, and all employers have to provide information to their employees about hazardous chemicals to which they're exposed by means of inter alia safety data sheets. And at paragraph 7, she explains at the end of that paragraph that the rules apply to ingredients used to make pharmaceutical products and to bulk products. That's an important part of the background in my submission. These are not documents, these are not patient leaflets, these are not things that consumers of the products themselves are concerned with. They are very specialist documents. We can put that bundle away because the rest is quoted in the judgment.
Sorry, was there some point there about this being US legislation? Because my recollection, which may be faulty, is that UK legislation requires SDSs as well.
I suspect that may well be true, my lord. The position is that the US company has given evidence that it, because it is a US company and deals with it on its US website, it seeks to comply with US legislation. There is evidence that says its website does not seek to comply with legislation throughout the world because it is US based.
Well, is that correct?
Paragraph
in
9.
Paragraph 9, she says it's based on the UN system, and in paragraph 12, she says, my group in the US responsible for drafting all the SDSs for all countries, we revealed local rules to determine the content. So that seems to be explicitly saying the exact opposite of what you just submitted.
My lord, and the end of paragraph 9 says there are similar rules for other countries.
Right.
Well, my lord, there are, as she says, there are similar rules in other countries. The reason that has triggered this, her evidence is that what she is doing is to comply with US federal legislation. I take the point that there are other similar systems elsewhere in the world. I'm not saying that this is something that was uniquely driven by the US legislation. I am seeking to point out that this is something which is a specialist document. It's not a product patient leaflet. It's not something which the end consumer of the products would be concerned with. Reverting, if I may, to the judgment. So I'm looking back on page 168 of the core bundle at paragraph 372. She's quoted there as saying that while we had in the past made the information available, we have not had a central external resource. She reviewed what a number of other pharmaceutical companies did and concluded they were collecting such information and providing it externally in one place. They started adding US SDSs, so those are the ones that were required by the US legislation, onto the Merck.com website, and then they started adding for other countries. Then she continues to say that they followed the brand guidelines in paragraph 12. At 13, we decided to create SDSs for those countries where the business had a manufacturing or laboratory presence, rather than trying to limit them. And at 14, they created an SDS for each product that had a bulk form. And then at 15, she is informed by counsel for the UK business that the UK research arm of MSD uses SDSs to transport research compounds that are made in-house between subsidiary companies. They may also provide an SDS as an email attachment to an order with World Courier to transport compounds to US sites. They do not provide internet links to our SDS page to third parties. So far as she's aware, the business does not otherwise use the SDSs. These are, in my submission, documents that in the ordinary course of business, which is referred to again in the quotation in paragraph 374, are not provided, there are no links provided in the ordinary course of business. To the contrary, in the ordinary course of business, if somebody needs them, they are provided with them directly. It is true that Merck.com has been used as a repository, but again, it is my submission that they are simply accessible there. Not only is there no evidence of how anyone would get them, the evidence is that nobody is directed there from the UK. Now, I would again ask if the court would allow me to show you what these things actually look like. And again, the starting point is Mr. Day's evidence, which is in S1, behind tab 7. And this starts on page 226. So at paragraph 88, he makes the point that safety data sheets for human and animal health products are available for download at that URL. And he says that screenshots, as it appeared on the 14th of October, appear at those pages of the exhibit, together with screenshots of the preceding pages that appeared when typing in merck.com/research and product/safety data sheets. Again, I make the same point. There is no evidence as to how anyone would arrive at that URL. Nobody in my respectful submission would in fact type in that URL. Within the context of this application, it is clear that the claimants have, with a fine-tooth comb, gone through the Merck website, as they're of course entitled to do, and found a small number within those tens of thousands of pages of uses of the designation Merck. But there is, in my submission, no evidence that anyone in the UK would actually, certainly not type in that URL, or how they would ever come across these things. Now, if we look at what we're talking about, also in this bundle, behind tab 11, so I'm looking on page 349, and if we turn over to page 350, regardless of how one does come across this page, the very first thing that one sees is the pop-up box, welcome to Merck.com, by continuing you will be directed to a site intended only for residents of the United States and Canada, and then the standard form about what they are called. And now this was an important part of our case, and the claimants accept it was not something that was referred to in the judgment, despite the fact that, as I showed you, he did say he would address them when he came to it. And it is in our submission significant for the reasons that my learned leader gave, that one is visiting the site, that this is a form of order control, and it's the first thing that one has to see and acknowledge before one continues. Then over the page there is another pop-up which tells you something about what the safety data sheets are, and again that they are specialist documents. And then on the next page, 352, there is a list. And by clicking on one of those products on page 354, one gets to the pages for a product called Bridion, a solution for injection, and one sees there that the safety data sheets for all countries have been made available. This is, as Ms. Basile explained, every country in which the business has a manufacturing or laboratory presence. And it is true that it does include the United Kingdom amongst all the other countries. But importantly, when one clicks on that link, so where it is at the bottom of the right-hand column, United Kingdom, when that is clicked on, one gets on 355 to a safety data sheet which is in compliant MSD form. And I note the reference to the regulation under the heading Data Safety Sheet, which picks up on my Lord Justice Arnold's point that these may indeed, I'm sure, are required elsewhere as well. But there is nothing objectionable about this safety data sheet. It is not suggested that this safety data sheet is using Merck or doing anything else improper. The totality of the complaint is that it is accessible as part of a repository of all safety data sheets, despite there being Yes. Just while we're here, the other one that is referred to is on page 358. This is one of two that's specifically identified. Here we have something called Bravecto, which are apparently chews for dogs. And again, when one clicks on the United Kingdom, you get a safety data sheet on page 359, again, compliantly using the MSD plan. So if we could revert to the judgment, please, and we can put S1 away. So I believe I'm on page 169. So he has set out parts of Ms. Basile's evidence, and his conclusion is in 376. It seems to me that making SDS for the UK available in a Merck branded environment was a breach of paragraph 2. These SDS were clearly targeted at users in the UK. In our submission, again, simply making available is just a statement of accessibility, and there is nothing to indicate that they were clearly or indeed at all targeted at users in the UK. He says that there was no parallel site on which the SDSs could be made available. They have been put on the msd.com site now, but in my submission that's not the point. The fact is that these are not things that people would go out of their way to look for. The unchallenged evidence is that those who did need it in the UK were provided with it, and no one in the United Kingdom would go out looking for them on Merck.com or at all. And as I've said, there's no suggestion of any linking, and in my submission that means there is insufficient for a finding of targeting or use in the United Kingdom. It is another example of simply focusing on one element of a site rather than looking at the site as a whole. Now he goes on in the following paragraph to find trademark infringement. I would like to deal with that briefly in the light of the observations we saw earlier, but I do need to just explain the circumstances in which the allegations of trademark infringement arose. You've heard what my learned leader said about that this morning. As you were shown, the judge took the view that it was not necessary to identify any particular goods or services, and this was back in paragraph 205 of his judgment. Paragraph 205, I'm looking back on page 135, refers to an amended annex identifying the goods or services relied upon.
I beg your pardon, give me the reference again.
I beg your pardon?
Could you give me the reference?
Yes, of course, I'm sorry, my lord. It's paragraph 205 on page 135. So I'm simply identifying that in 205 he refers to an amended annex, which I will show the court, if I may, in a moment, before going on to the points which my learned leader drew your attention to at 211 and 212. Particularly in 212, the assumption at the bottom of the page, if it is assumed that the use of these email addresses, this is by reference of an example that I gave to an email address, if it is assumed it did constitute use of Merck as a trademark, this necessarily assumes that the email addresses were being used to promote some goods or services, and if that is the case, if it's assumed to be happening, I have some difficulty in seeing how they could not possibly be at least similar. As your lordship pointed out, it's not a question of similarity, it's a question of any goods at all. So that schedule is in this bundle, and to put it in context, we had made a request, and that's behind tab 12. These are part 18 requests, and on the second page of that, so it's bundle page 286, Request 2 says separately in relation to each and every row in Annex 2 in which breach of paragraph 3 is alleged. We've asked which of the defendants, the basis on which they're said to be liable, and then C, please specify the goods or services in relation to which that defendant is alleged to have used the sign Merck as a trademark in the course of trade in the United Kingdom, and state whether they are alleged to be either within or similar. So that was the request that was made. The following tab are the points in reply, and it is said at the end of the points of reply that they would also deal in the schedule with that Part 18 request, and one can see that at page 290 and onwards. So this is a version of the Annex 2 that had been attached to the application, on which that right-hand column had been added. And the heading of that right-hand column is goods and or services in each of the claimant's TM registrations in issue that are relied on in relation to that defendant's use of the sign Merck. So there isn't actually an identification anywhere of specific goods and services alleged to have been used by a defendant, merely an allegation of what the specifications covered, and there are then set out in the rows lengthy portions of the trademark coverage. And so we're looking here at row A, and there is a long part quoted of the first international trademark, and that integer goes over 2.5 pages, and one can see on page 292 that in relation to a lot of these rows it simply says as per row A, and that is included, for instance, also in row I, which is one of the Merck email addresses. So I've moved on to page 301. And row I is alleging that the use of the Merck.com email addresses for contacts listed on the media library page at msd.com/media are said to amount to use in relation to all of the specifications as per row A. There is and there was no finding that any email addresses were used in relation to any specific goods or services, and hence that antecedent question was never addressed. There is simply the general points that I have drawn the court's attention to, as my learned leader did this morning. There is the suggestion, well, if there is use as a trademark, it must be used in relation to something. And in our submission, that's not a shortcut that is open. It is necessary to say, when you're looking at an email address, where is their use in the United Kingdom in relation to particular goods and services, before asking the question, are they similar to any of the ones that have been identified in this table? For completeness, we've just been looking at row Q, and that appears on page 304. So it would, in my submission, have been necessary for a finding of breach of paragraph 3 to identify that there was use in relation to use of the sign Merck in the United Kingdom in relation to specific goods and services, before asking the question whether it was similar to any of those relied upon in the long list on page 304, and in particular having regard to the fact that the marks for veterinary products had been revoked, as the claimant doesn't have an animal health business, in particular when one is talking about dog chews, as the second safety data sheet was. In my submission, that was a necessary part of the analysis, which wasn't done. Stepping back, my lords, my lady, for those rows that I've just shown you, it is our submission that the judge took what was characterised in the Amazon case as an overly simplistic approach. It was simply just relying on one factor whether that was the presence of a handful of UK jobs or the presence of UK safety data sheets, it was in our submission missing the wood for the trees and treating individual items of content as determinative when in fact viewed as a whole there was no targeting of that material for the purposes of paragraph 2, and certainly no use or no finding that would have enabled, no determinations that would have enabled a finding of breach of paragraph 3. Now the last of these in our skeleton relating to use in the UK and targeting is rows E, E and FF. And these are addressed in the judgment at paragraph 462, and that is page 187 of the bundle. And as is set out at 462, these complaints relate to company statement links from the MSD website to news releases hosted on the Merck website. As he says, these are more complicated to set out than in other rows, and I'm afraid that is the case. Just to put this in context, all of these statements were about a new drug for COVID called molnupiravir. He refers in paragraph 463 to 4 such news releases, and he then sets out the route taken by the user, which I accept as being accurate factually, and he then refers to a further company statement in 469, so there was a 5th one, and again he refers back to the journey. Whilst I have accepted those as being accurate, I would, if you will allow me, like to show you one example, again to put it in context, and that can be done in bundle S1. So behind tab 16 of S1 is the first of those examples that was referred to in evidence. So on page 417, just to be clear here, we are on the msd.com site, and there is a heading on that site: our investigational antiviral COVID-19 medicine receives US FDA emergency use authorization.
I think I must be on the wrong page. Can you give me the page again?
Of course, 417 in bundle S1, my lord, it's behind tab 16.
Thank you.
So that is a heading on the MSD website, and at the bottom left it says company statement. If one clicks on company statement, you go over to page 418, and we see again on the MSD website, MSD and Ridgeback's molnupiravir receives US FDA emergency use authorization. So just pausing there, there is nothing objectionable about the text that appears on the MSD site in any of these examples. One sees the date there, it's December 23rd, 2021, and you can click there to read the news release. Now, for reasons that I'm going to have to come on to try and explain, when one clicks on that news release, what happens appears on 419. A pop-up box appears which says you are leaving msd.com. You're now leaving this website. By continuing, you'll be directed to a site intended only for residents of the United States and Canada. And you can click either on cancel or on continue. Just pausing, that is the form prescribed by paragraph 4b of the order. And in this context, we do rely on it either under 4b or in more general terms in the analysis of whether there is use in the United Kingdom what we're loosely calling targeting. To be clear, that appeared in all 5 of the instances complained of. That was in all of them. Page 420, there is a further pop-up when one arrives at Merck.com, which you can see on 420. It is fair to say that appeared on some but not all of the journeys, but for those that it did, there is a still further indication that you are being directed to a site intended only for residents of the United States. This is the border analogy that my learned leader developed this morning. And so when one arrives at 421, one does indeed arrive on the US website. And so you can see that you have landed on Merck.com, and there is indeed use of the sign Merck, and that happens throughout the press release because this is the US site. So I don't deny, of course, that Merck appears many times in this release. Again, the date is important, 23rd of December 2021, and just while we are here, if I could invite the court to go right to the end of that press release on page 436. At the end of the press release, in bold, it says, please see the Molnupiravir FDA letter of authorization, and there are various links, including links to a fact sheet for patients and caregivers. That is at the end of that paragraph. Now, reverting to the judgment, so I think we can put S1 away. So I'm back in the core bundle at page 188. And at the bottom of the page, at 471, we see that this is alleged to constitute breaches of paragraphs 2 and 3. Over the top of the page on 189, it is correctly recorded that we are relying on subparagraph B, but not, in this case, on subparagraph H. There is then a reference to some of the evidence, and I will come back to that as necessary. But finally, we get, after the assessment of 4B, to the general question of whether this is use, whether there is targeting, at 479. So 479, this leaves the general question of whether the use of the links from the MSD website to Merck branded material constituted breach of paragraphs 2. And he does record there that we rely upon pop-ups, but in 480 he says the pop-ups were insufficient to avoid the Merck branded material being targeted, and he says this for 2 reasons. First is that the evidence of Ms. Ronaldo and Ms. Choi shows that this was a matter of deliberate policy. It was not an accident. I accept that, my lords, my lady, but to say it was a matter of deliberate policy is really no more than saying it wasn't inadvertent. What he doesn't address is that the evidence did explain why there was that deliberate policy, and it is my submission that there was a good reason for that policy. It was not simply, as the position back at the time of the first instance trial, where MSD was simply a portal for all material, there was a particular reason why this was done in this instance and not in other instances, which I will come on to. And he then goes on to say that this was an issue that appeared to have been addressed in the previous judgments. So may I just deal with those 2 points? First, the point about the deliberate policy. As I've said, there was a particular reason for having the policy, and Sir Alistair had expressly contemplated pop-ups being appropriate where, through necessity or indeed policy choice, there are links. Now, I have some trepidation about going into this because the reasons are not entirely straightforward, but I hope I can, by reference to the evidence, explain the reasons for having that policy. The short point is, before this drug, molnupiravir, received emergency use authorization, so before the EUA, there were separate Merck and MSD statements. So there were separate statements that could be linked to. After the FDA granted that emergency use approval, there were not. The business took the policy decision that there should only be a Merck branded statement from that point on. And that was the reason that meant that this was linked to, because there was no equivalent MSD version that could be linked to in its place. Now, the judge has quoted parts of the evidence of Ms. Choi in his judgment, so I'm just turning back from where I was. I don't think I need to go to the evidence of Ms. Choi, but in paragraphs 473 and 474, he quotes parts of her evidence. She explained in her evidence, in parts that aren't quoted, what I've just said, that there was a different process used when news releases were either before or after the grant of the emergency use authorization. And some questions were asked about that by the claimants, and Ms. Choi couldn't answer them because she was on maternity leave, so Ms. Ronaldo answered them. And I'm hoping that if I can invite you just to read a handful of paragraphs from Ms. Ronaldo, that will give the essence of the reason behind this decision. And the court will find that in S3, behind tab 40. So it starts in S3 on page 820. But if I could ask the court please to go forward to page 824. I don't know if the court has picked up on the fact that after the witness statements were served, very lengthy so-called Part 18 requests were served, asking many, many questions about different parts of the evidence, and the defendants answered those in supplementary witness statements, of which this is one. So on page 824, there is a question that says, please confirm that publication on the MSD website is capable of meeting the regulatory requirements for publication of information in the USA and Canada, and if not, please explain why. So this is very much directed to the question of, well, why can't the company statements be published on the MSD website? And I think it would be quickest, it's a fairly long answer, but if I could invite you to read particularly paragraphs 24 to 27, and then the conclusion in 32, I think that would be quicker than me trying to explain it.
doesn't seem to me to be an answer to the question. There we go.
Well, my lords, my lady, the position as set out there is that as a matter of US law, information making claims about an approved drug must be accompanied by a fact sheet.
Sure.
And that can be in the form of a hyperlink. And that because the company does business in US as Merck, those fact sheets may use the sign Merck. And therefore, there has to be a link from the press release to the fact sheet, which may contain Merck and which is contained on Merck.com. So they have taken a decision that it is sensible to have the press releases on the Merck.com website, since they are linking to other material on the Merck.com website. Now, your lordship may say that may not be an answer, but I submit that it is a sensible and rational reason for them proceeding in the way that they did, and for adopting this position after the US approval had been granted, whereas before that, they didn't. They did have two separate releases. Now, when considering the form of order, Sir Alistair did expressly recognise that such situations could arise. And we've quoted part of that in our skeleton, but may I ask you to go to the judgment itself in bundle CS, the core supplementary, tab 4. I'm looking on page 189 of the core supplementary bundle. So just to put this in context, this is after the first trial. The Court of Appeal has remitted, amongst other things, questions of relief, and the questions of relief has come back before Sir Alistair, at which point there was some evidence about what steps had been taken since his first judgment. And at 114, he notes steps that have already been taken, including in little Roman 2 at the end of the third line. In parallel, it is developing an MSD.com website with revised architecture, linking it to new MSD-related websites, and using the word Merck only in forms authorised. So that was the beginnings of the procedure which I showed you in Ms. Herman's statement that had now been put in place. And then about 2/3 of the way through that paragraph, so about 6 or 7 lines up, at the end of a line, he says that it identifies, so that's US Merck identifies, a number of respects in which it is not possible for the MSD site to be a clone of the Merck.com site. There will therefore remain rare instances in which MSD.com sites are in specific respects required to act as portals to Merck.com site. And then he gives one example of investors affording access to financial information. And then there appear to be other occasions when Merck US has taken a policy decision not to put information on the MSD.com website, but to place it on Merck.com website, e.g. Information contained on its corporate site. So he's recognised that there will be situations when this have to occur, or this may occur. He nevertheless says that a framework is required in 115, but there will be carve-outs. And at 116, he says the specific carve-outs will relate, 1, to any link from an MSD.com website to a Merck.com website, which generates a pop-up informing the user that they are landing on a page belonging to a Merck US entity, accompanied by a proper geographical identifier. And then at 117, he says I should deal at greater length with the first carve-out, in part through necessity and in part through policy choice. Merck US intends to retain some links between MSD.com and Merck.com. In my original order, I directed that use should generate a pop-up. The parties are agreed that a pop-up would be sensible, but disagree about what it should say. And he goes on to prefer the wording of the defendants. And at the end of that 117, he says, I consider that this was a proportionate measure counteracting past use of the msd.com website as a portal to Merck.com. Just pausing there, my learned friends have suggested in their skeleton argument that there were no MSD sites at the time of the first trial, so Sir Alistair can only have been referring to MSD UK, the specific MSD UK site. As I hope I've shown you, by the time he's actually considering the remitted issues judgment, there was, in the process of development at least, an MSD.com site, and he was specifically contemplating the need for links. Now, we do, of course, rely upon this in connection with paragraph 4b, but I'm referring here more specifically to the more general question about targeting. And it is my submission that it is clear that the use of pop-ups was in the contemplation of the parties, and it cannot be characterised as some sort of fig leaf, as my learned friends attempt to do, certainly not when it is part of a policy decision that has been taken in the unchallenged evidence of the defendants. There is a reason why they've done that. So putting that core supplementary bundle away and reverting to the judgment, we do say that it was an error in paragraph 481 to regard the fact that there was a deliberate policy as a matter counting against the defendants. There was a rational reason why this approach had been taken, and in my submission, it actually should count in the defendants' favour, not against them, in the way that the learned judge held. The second part of his reasoning is paragraph 482, where he draws support from the reasoning of Mr Justice Norris and Lord Justice Kitchen. As my learned leader was at pains to point out this morning, those were made in very different factual contexts, and we have made that point in our skeleton argument. I don't think I need to go to it again, but it's paragraph 43 and following for your reference. It was in that context of the suite of global websites, the absence of MSD.com websites, that led to the comments that are being referred to in paragraph 482 of the judgment. There is in our submission absolutely no indication in any of those judgments that either Mr Justice Norris or the Court of Appeal thought that pop-ups could be simply swept aside. They are matters that need to be taken into account, and in our submission it is wrong to start from an assumption that there is targeting and then simply say, are pop-ups enough to counteract that? As part of the holistic stage-by-stage approach required by the Supreme Court in Amazon, it is necessary to take them into account, and it is our submission that users will understand that they are indeed visiting a US site, and that that is not the targeting of material, certainly not the targeting of any use of Merck at the UK, such as to constitute use in the UK. I hope I can finish this section by reference to row FF briefly. And the reason I do that is because row FF actually sheds light on row EE, because this was an example of the situation before the emergency use authorisation was granted. So it is not the same, and it is for that reason that 4H is relied upon. This was inadvertent. So if one continues in the judgment, so I'm in bundle C, the core bundle at page 192, paragraph 488. This is a link from the MSD COVID research website to the Merck.com website. Again, I accept the summary of the journey that's given in 408 to 490. But as he notes in 491, in this case, we are also relying on paragraph 4H. He deals with it briefly by applying the same analysis at 494. He says there in the third line, I refer to my analysis of row EE. We say that he was wrong to effectively discount pop-ups for the reasons that I've given. But additionally, as I've said, what is important here, my lords and my lady, is that this occurred before the emergency use authorization was granted. This instance, as recorded in the judgment, paragraph 490, the news release was on the 1st of October 2021. The emergency use authorization was on the 23rd of December 2021. So at that point, there was no approved fact sheet that either needed to be or could be linked to, because it was before that had happened. So the defendants could, and they did produce, parallel Merck and MSD branded statements. They are both in the bundles. I don't think I need to take you to them, but both the Merck and the MSD versions are there. And in my submission, this actually supports the submissions in relation to row EE, that where it was feasible to produce parallel versions, that was done. It was only after the emergency use authorization that the Merck version was linked to. And thus, for row FF, this was simply a mistake. It was the case that the MSD version, which did exist, should have been linked to, and by mistake it was not. It's not clear whether the learned judge appreciated the difference between EE and FF as a result of that emergency use authorization. It seems, with respect, maybe not, because he treated them in the same way. But if one looks at paragraph 492, he quotes the evidence of Ms. Cantor. I haven't really got the time, and I don't think it's necessary to take you to it, but it is in the bundles. It's at tab 20 of S2, and I submit that it is absolutely clear, if one reads it, that she was acutely aware of the need to differentiate between MSD and Merck. She took steps to make sure the correct website was shared with the correct people. She was well aware of the brand guidelines, and the paragraphs that are quoted in paragraph 492, in particular paragraph 25, when she says at the end, I should have directed StudyKick to link the company statement on msd.com instead, was indeed an inadvertent error. She made a mistake, and it should be understood in that context. She simply used the wrong version when there were two available. It's held that that's not the case in 495. Our submission that it was. This is plainly, it was an accident, it was a mistake that she told them to link to the wrong thing. She knew perfectly well what she was supposed to be asking them to link to, and that is, in our submission, an inadvertent error. Now that concludes the section of our skeleton dealing with the targeting or the use in the United Kingdom, and has sort of naturally segued into the question of inadvertent error. I don't think there is much to be gained by going to many examples, but if the court would be willing to let me perhaps point out one or two examples of the other instances, I can do so quite briefly. They are referred to in our skeleton argument. So in the core bundle, I've just been addressing you on paragraph 70, our skeleton argument, paragraph 88, deals with the linking exception, and I've shown you, so this is page 44 of the core bundle. You've now seen EE, and I briefly addressed you on FF. Nothing more to say about that. Then the email address exception, which my learned leader addressed you on this morning. At the in paragraph 92, we've identified various rows where we say the result was wrong as a result of that approach. And finally, in 103, page 47, some errors as a result of the misapplication of paragraph 4H. I wonder if I could perhaps show you row U, because that appears in both of those paragraphs as both a D and an H example. So perhaps if I could ask you to look at that, that will do, as it were, double duty. This is in the judgment, so I've gone back behind tab 5 in the judgment to paragraph 322. And he says in 322, row U also concerns an email address, and it refers to a PDF document entitled Independent Grant Request MSD Oncology Policy Grant Programme, hosted on the MSD UK website. And if I could show you what that looks like, please. That's in bundle S1. Behind tab 12. And one can see this from pages 369 onwards. So on page 369, we can see we are on the MSD UK website, which is compliantly MSD branded throughout. If one turns over to page 370, there is at the bottom there a heading Global Oncology with some text against the grey box. And at the bottom, find out more about our global oncology grants here. And clicking on the word here takes you to the link for the PDF complained of. So just pausing there again, there is nothing complained of on the site, on the text of the website, but then when one clicks on that link, it opens up in 371 a PDF document, which is the independent grant request. Again, one can see it's quite a long document, and throughout there's nothing objectionable in it in terms of its content, apart from the fact that right at the bottom of the document, so I'm now on page 372, 372 at the top of the page has a little paragraph E with some sub-bullet points, and then it says, the application shall be sent via email to our US-based MSD Global Oncology Policy Team at oncopology02@merck.com. And I would just draw your attention, and also related to at the very bottom of that page, the date is September the 8th, 2020. So that is the totality of the complaint. Again, as I've said, the claimant is entitled to comb through the materials, but it is one small point in a large website. And if you could put that away, please, and go back to the judgment, we can pick it up with the references to the evidence. So I was on page 158 of the core bundle, looking at row U, and at 324, the evidence is given by Nikki Carpenter, and parts are quoted. I don't need to read that out or go to other parts of her statement. Her statement makes it clear, unsurprisingly, that the MSD Oncology Policy Grant Programme was managed by the US-based team, and that it's run annually and administered by one person in the team on a yearly rotation, and Thomas Bragar was the person at the time. So that's the context against which we see the quotation. So turning over to page 159 of the bundle, paragraph 12 of her statement is quoted. The grant request included the email address oncopology policy02@merck.com. It's used to manage applications, and the responses were monitored by Thomas Brager as the individual responsible for the programme in 2020. It allowed us to use the same address each year. It gave consistency. And then in paragraph 14, Thomas was not aware that it might not be acceptable for an @merck.com email address to be included in materials if the employee was based outside the UK. I understand from, this was the UK Council, that email addresses for UK personnel were moving from @merck.com addresses to MSD addresses. It appears that the UK review did not identify that as an issue. Now, you have heard the submissions about whether or not that falls within subparagraph D. I would pause to note there is, if Thomas Brager had in that policy used Thomas Brager @merck.com, that would certainly have fallen within D. But as to subparagraph H, the context of this is that the final order had been granted on the 28th of July that year. It came into effect for email addresses 3 months later on the 28th of October 2020. That's not in dispute. This document that we've just seen was dated the 8th of September 2020. Now, I'm not saying because it was earlier it's not caught. I accept it was on the website after the 28th of October. But it does, in my submission, provide context for what is going on and what Ms Carpenter is referring to in paragraphs 14 and 15, that email addresses were in the process of being changed. And if I could invite you to look at our skeleton argument, which is in tab 2 of this bundle, we have quoted what Mr Justice Norris said at the time. It's page 44 of the bundle, paragraph 90 of the judgment. This is in his remitted issues judgment, in which he was considering what the scope of the changes to email addresses was required to be. And he addresses that in what we've quoted, para 127. The general prohibitory injunction as a contracted corporate name has what was characterised as the implicit or repercussive effect of requiring a change of email addresses. On the evidence I've heard, I'm content it should have that effect for employees based in the UK, because that is a necessary and proportionate response to the breaches. It's not technically complex, and so on and so forth. And then the part we've underlined, it was never intended to have that effect for employees based in the permitted territories, because Merck US is plainly entitled to use Merck.com for its own employees within the territory where it has exclusive rights to that name. Against that background, I submit, my lords, my lady, it was entirely reasonable that Thomas Brager, based in the United States, should not have appreciated in September 2020 that whilst the use of his personal email address continued to be fine, the use of a team email address might not be. And it was also entirely reasonable that the UK review team wouldn't have identified that as an issue. The evidence, both quoted in that part of the judgment and elsewhere, shows that substantial efforts were being taken to ensure compliance with the order, and they had succeeded in every other respect in regard to this particular complaint. There's no suggestion there's anything else wrong about this particular document or that any employees in the UK have been using in breach. And it is my submission that this is an example of one of the many and varied examples where this conduct can and could properly be regarded as inadvertent, so as to fall within paragraph 4H. Ultimately, I've gone through that at some pace given the time, but that does give...
Judge is fine.
my attention's just been drawn back in the judgment at 327 and 328 on page 159 that this was not a case of an accidental oversight. The inclusion was deliberate. No one appreciated at the relevant time it should not be used. Well, at the relevant time, it was still not technically impermissible because the order hadn't come into effect. It is true that subsequently it was not picked up on, but that is in my submission an example of a case when subparagraph H could and should have applied. Now, I don't think, unless the court would wish me to do so, going to further examples that I have highlighted is going to serve a great deal of purpose. There are other examples, including an apprehension that it was permissible to use to refer to the manuals, the Merck manuals, and I would, this is row W. I would simply point out that Sir Alistair had specifically recorded in the remitted issues judgment that Merck Global did not object to the use of that title in relation to physical hard copies of the publication, and that, in my submission, is another example of a perfectly valid reason for something being inadvertent in row W. But as I've said, unless it would be of assistance to go to any of the others, I'm aware I have wearied your lordships and your ladyship for quite a long time with the details of this. So I would not propose to say anything else unless you would wish me to.
No, thank you very much. Yes, Mr. Speck.
My lords, my lady, before I work through each of my learned friends' grounds, can I start by spending some time explaining the long history of this matter, perhaps actually up until we break for today. My friend would have it that the cause of these proceedings, and indeed proceedings elsewhere, is a change of attitude by my clients, upsetting the apple cart, as it were, after years of cordial cooperation that his clients were keen to continue with. That is not a fair representation, and neither does...
Do we need to go into all of this? I mean, we've read into it in extensive detail. You've each had a go at each other in the nicest possible way, saying it's not my fault, it's their fault. It doesn't actually, with respect, help us to understand what the answers are to the points on this appeal.
I understand why my lady may say that, and what I was going to do is to try to give you an overview, because there are some aspects to what I was going to point out that I have to come back to in isolation. Now, I can do that without giving you the big picture of the constantly pushing up boundaries that my clients have had to deal with since about 2009. Things like the pop-ups being used as a fig leaf, which we see in Lord Justice Kitchen's decision. Now, there are all sorts of things, little things like that, which I am going to be referring to, and I was going to try and give my lady an overview of how we got to where we are. But I can, and in fact, in the light of my lady's intervention...
That's my lords, but speaking for myself, I wouldn't find it at all useful, Mr. Speck.
Well, in which case I will skip straight to ground one. I was going to spend 20 minutes or so showing my lords and my lady how the issues developed and what were the key issues on appeal and so forth, and the way in which they behaved. But I will skip straight to ground one and deal with that straight away. Now, can I just outline what the nub of the contention is on this? It's that we must proceed against them by making an application to commit them for contempt of court or not at all. That seems to be the nub of the dispute. That they don't say that if we think they're in breach, we can't do that. What they're really saying is we must do that. We can't go for a more low-key application to resolve the dispute as to whether or not they're in contempt, or in breach, sorry. We've got to go for contempt. And that's really what this fight is about. And they deal with it in paragraphs 20 to 40 of their skeleton, on pages 27 to 32 of the core bundle. And as I've just said, the nub of the argument is there's only one way to resolve disputes as to whether a court order has been complied with or breached. That nuclear option. And we drew attention to the fact that my learned friend's skeleton contained a flurry of authorities, particularly in paragraph 24 and 25, none of which seem to be on point. Of the 10 cases cited there, they've only bothered with 3 in the authorities bundle. Even they don't help very much, but I'm going to show my lords and my lady what happens there, because that seems to be their best cases. So they are in rear child, the Financial Services and Rorke case, and the Bus and Coach Association case. So I'm very briefly going to show you that that doesn't help you, but there are marked passages which I assume that my lords and my lady may have looked at. So can I take them in turn? So I'm in the authorities bundle, tab 7 for the rear child. It was a case where a relative of a child who had been made a ward of court and thought to have been abducted by her parents was compelled at a hearing to give evidence without representation, and then committed for contempt of court in relation to a previous order in which he'd been one of the named individuals required to disclose any information as to the whereabouts of the child. And I have to say, I am at a loss at what my friend says he gets from this case. He's marked the holding on page 99, which deals with the fact that it's impermissible to compel a person to give evidence, denying him the right to remain silent, and then use his evidence against him in support of committal. And then he's also marked 3 passages in the judgments. The first is in Sir James Mumby's judgment. It starts at the foot of page 110. Runs on to page 112, and that deals with the fact that an individual in committal proceedings has an absolute right not to give evidence, i.e. that they're not a compellable witness, which is a different thing to privilege against self-incrimination or legal professional privilege. Those 2 matters are concerned with the right to refuse to answer particular questions, not a right to decline to give evidence at all. And that's most apparent in, for instance, paragraph 31 on page 111. The focus of this whole marked passage, including the long quote from Thorogood on page 112, is that a committal application at the same time as other aspects of proceedings is incompatible with the right to remain silent. That's what that passage is all about. Not going to help my lords and my ladies very much on this application in my submission. The next marked passage is at the foot of page 119, over the top of page 120. In that passage, the President addresses confusion in the court below in referring to the committal proceedings starting on the 8th of October 2015. That, just for my lords and my ladies' note, was the occasion that Mr Odin had given evidence before the judge, which the judge hadn't believed. But of course, at that point in time, there were no committal proceedings. The reality was the evidence was extracted on the 8th of October before committal proceedings and then used in the committal proceedings on the 18th of January. And we see the fatal issue identified right at the foot of page 119. Mr Odin was denied the safeguards anyone facing committal is entitled to, the right to remain silent. Now, the third and final marked passage is paragraph 75 on page 124. This is in fact Lord Justice Voss, as he then was, and that explains that the process for committal for contempt is highly technical in nature, but for a good reason, and it explains persons should not be at risk of being sent to prison for contempt unless the 5 points listed here are met, which includes point 4, their having been informed of their right to remain silent. My lords, my lady, all of this is miles from our case. Nobody, whether individuals or the corporate defendant, is at risk of being exposed to any penalty, going to prison, or any other penalty for contempt of court. And that's just not what's ever going to happen in this situation that we're in. And the whole fallacy underlying the argument is the suggestion that we will come back using the decision here as what my friend calls a platform. He calls it a platform to commit for the same acts. Now, we've disclaimed that in the clearest possible terms. Of course, the fact they may continue to act in that way that we complain about after judgment, we might next time apply to commit. That's nothing to the point in my submission. And it's no different to a point that my Lord Justice Phillips raised with my friend in his submission. No different and no more objectionable, where there's been a dispute and a trial. The example that I was going to give you, given the courts in which I practice, was to say an infringement of a patent. A defendant loses at trial and is told its product infringes or its apparatus infringes a valid patent, contrary to the contention that it ran at trial that it didn't, and thereafter it will be enjoined that it's got to stop. And if the defendant continues thereafter, it's quite possible that the patentee might apply to commit, particularly if the acts are technically totally indistinguishable from those that were the subject matter of the trial. But that is no objection at all. Of course, the order prohibiting the continued infringement doesn't exist at the time of those earlier acts in my example of a patent trial, and in our case the order did exist. That is the only difference, but because of my disclaiming any application to commit for the past, there is no relevant difference in my submission. So if a claimant disclaims any possibility of seeking committal for the acts which are subject to the declaratory application to determine the dispute over whether they're in breach, there's no danger of any person being subject to committal application, and they are in effect in the same position as any person or company that fights a trial and loses. So that's that case and what I say about why it just doesn't help you and why I explain, or why I was going to develop a point which in fact my lords are already aware of from the point that I saw my Lord Justice Phillips put to my friend. Can I turn to the second of these cases, which is the Financial Services and Rourke case? That's tab 2 of the authorities bundle. Now, my lords and my lady will recall that the case was considered in great detail by the judge in this case over 3.5 pages. That's paragraph 67 on page 97 to paragraph 73 on page 100. None of that part of the judgment was identified by my friends in the skeleton argument as being in error. I don't think he identified any of it as in error orally either. What the Rourke case concerned, as my lords and my lady may recall, was a bookkeeper who was running an unauthorised deposit business. Unauthorised in the sense that the claimant, the Financial Services Authority, hadn't authorised him. And the aspect of this judgment that we're concerned with is the declaratory relief that was sought. Now that relief is set out on page 32 of the bundle, was actually as to factual matters identified here.
Well, but is it? Look at 1. It's in contravention of section 3 of the Banking Act. So it's not a pure question of fact, is it?
Not a pure question of fact, although certainly when the judge is dealing with whether he should grant it, he treats it as if it's to deal with fact. So, in fact, off the top of my head, I can't tell my lords and my lady whether or not the declaration granted might have been slightly different. I will look at that over the long adjournment, because this is what was applied for. And when we get to see his reasoning, he definitely is focusing on the fact that it's factual matters. But I can certainly see why.
Granted the relief that was in the same terms that was sought by the FSA.
Right.
And I think that's page 32.
Right. So it looks as if perhaps it went a bit further than just factual matters.
Yeah.
But when we see the way in which Mr Justice Neuberger describes it, he definitely focuses on the fact that it is factual. Anyway, I totally take the point that my lord's just put to me. But what it is directed to are 60 individual occasions when he accepted deposits, and secondly, the statements identified in paras 2A to D as to the statements were made contrary to the fact as to the deposited money being used for particular purposes. Now, the passage marked up by my friend continues over the next page and a bit by setting out some general material as to the general power to grant comparative relief. And page 33 ends with the key bit in my submission, Mr Justice Newberger stating that when deciding whether to grant a declaration or not, the court should take into account justice to the claimant, justice to the defendant, whether the declaration would serve a useful purpose, and whether there are any other special reasons why or why not the court should grant the injunction, the declaration. And that, in fact, is a short passage that you'll have seen that we ourselves set out in our skeleton. We adopt that. The mark up by my friend continues by the top hole in page 35 on the issue of whether declarations ought to be granted as a matter of discretion in that case. And what the judge asked himself first was why they were asked for. In other words, he's just looking at the claimant's side of things. And my friends have only marked the beginning of this passage, setting the scene for the reasons advanced as to why the declaration might assist victims of unauthorised deposit takers. And actually the thrust of what follows down through the bottom of page 35 is as to the ability to publicise the findings, to investigate the deposit taking, particularly where there were confidentiality concerns under the Banking Act, which in turn, and this is really the end of the paragraph at the top of page 36, for the depositors to consider what remedies they might wish to pursue. So those were the considerations, and the upshot, and this is the next marked passage on page 37, was that the declarations would be expected to have some effect and they would be beneficial. Now the second marked passage is Mr Justice Newberger moving to consider if there were any reasons why not to make the declarations. And there were 3 points considered here. First, the issue of whether it was appropriate as a matter of principle to grant a declaration in civil proceedings in connection with a matter which also had potential criminal aspect.
Yeah, and he does recognise at that stage that what's under discussion is breaches of Section 3 and breaches of Section 35.
Yeah.
Yeah, and I think we get to the point where he makes a particular point about how that particular act has a, I think he calls it a twin route in both the criminal and the civil courts.
Yes.
The potential criminal aspects was not actually a point pressed by Mr Rourke's counsel. Second point, though, was a point which was pressed, was related to that, was a suggestion that if you made the declaration, that would mean that there was no fair trial could take place. And the third was a Human Rights Act point.
And the second point he didn't accept on the basis that even the declaration wouldn't have been admissible in any subsequent criminal proceeding.
Indeed.
It's a matter of evidence.
But I also think he said that it's a matter for the financial services authorities to take that risk if they wanted to. I suspect I'll say that again if it's covered in my note, but my lady's right.
That's the top of page 40.
Yeah. The first issue obviously involved considering the Imperial Tobacco case. Yeah. And that's a very different case where there was actually an attempt to preempt criminal proceedings by coming to the civil courts and asking for a declaration. And his lordship quotes extensively from that Viscount Dilhorn and Lord Lane before concluded, and this is, I'm afraid I'm still back on page 39 near the top, the Imperial Tobacco case was authority for the proposition the court has a very wide power to grant a declaration, confirming his conclusion that in such circumstances as the Imperial case it would be inappropriate, but that's just where you're trying to preempt a decision coming in the criminal courts. And he went on to explain why the Rourke case was different. So we're now back into the marked passages. There by the top hole on page 39, there were no criminal proceedings underway. What was sought was merely a declaration as to events that had taken place. That's the point where my Lord's observation may come in, that it was perhaps slightly more than that. And his Lordship also pointed out that it was properly under consideration by the High Court. The Banking Act was what the judge said had this unusual twin tracking. Further, the judge also explained that the declaration would not in any way inhibit criminal proceedings, and he makes the point that my lady drew attention to just a minute ago. It wouldn't even be admissible. And the next paragraph highlighted the difference in the burden of proof. And the paragraph by the bottom hole emphasises how different this case was to Imperial, which was a case solely brought for the purpose of assisting a defendant in criminal proceedings. So that's dealing with the first point. The second point is dealt with from the bottom of the page, which is the inability for a fair trial. My friend hasn't marked it, so I won't dwell on it, save to point out that the argument was rejected, culminating in the conclusion that it was for the FSA to take the risk, face the contention later on that any proceedings that they decided to start couldn't be fairly tried. And that brings me to the final point that my friend has marked, which is the Human Rights Act point, which Mr Justice Neuberger begins by saying, like all human rights points, it can't be regarded as absolute. And this right was the right to be presumed innocent of a crime, and the second is the right to examine witnesses against Mr Rourke. Now the first, so that's the Article 6.2 presumption of innocence, is dealt with briskly, as these were not criminal proceedings and Mr Rourke wasn't being declared to be guilty of an offence, so there was no criminal stigma. And in any event, this is the top of page 41, Mr Rourke had been proven to have acted in the way captured by the declaration, so they had actually been proven. The right to examine witnesses as an issue was also a non-point, and in fact is not marked, so not relied upon by my friend anyway. The conclusion in this case was that it was appropriate to make the declarations. Can I just pause here before we go on to the third one and just show my lords and my lady what the judge took from all of this? Can we turn him up at page 100 in the bundle? So we're in, I think it's tab 4 in the court bundle, paragraph 73. Because he did look at this case with a lot of care. So I'm in paragraph 73. He agreed that there is an overlap, where there's an overlap with criminal or quasi-criminal jurisdiction, there's a need to be wary where there's a claim for declaratory relief. But he also explained that the judgment of Mr Justice Neuberger brings out the case-sensitive nature of the jurisdiction to grant declaratory relief, that a careful examination of the area of overlap or potential overlap is required before the court can decide whether a case is one in which it should grant declaratory relief in relation to the question of whether an order of the court had been breached or not. And as we shall see, that's exactly what the judge did. And he can't be criticised for this conclusion here. Indeed, I didn't actually detect any criticism in my friend's skeleton as to that conclusion, or indeed orally. So he looked at that authority very carefully, and the conclusions that he took from it are, in my submission, unimpeachable. And he followed it. Of course, the case was very different that he's dealing with here, but perhaps there are parallels with the twin tracking point. There is no twin tracking here. My friend complains about potential contempt proceedings. Even if there were, that is not a matter for criminal courts at all. There's never any conflict with criminal courts in this case. So that's what the judge took from the Rourke case. Finally, in this group of three authorities that are relied upon from paras 24 and 25 of my friend's skeleton is the Bus and Coach Association limited case at tab 9. And can I just deal with that as well? This is a judicial review case about the meaning of an exception contained in an EU regulation governing road transport operators. And the exception was for undertakings engaged in road passenger transport services exclusively for non-commercial purposes. And the essence of the dispute can be seen in paragraph 2 on page 166, that the Secretary of State had been relying upon an alleged lack of clarity as a reason for not prosecuting certain community transport organisations, allegedly providing road passenger transport services for commercial purposes within breach of the regulations. So the Secretary of State wasn't doing what a trade body wanted the Secretary of State to do, relying upon an alleged lack of clarity. And the Secretary of State's position was that the legal uncertainty was relevant to the decision as to whether there was a public interest to bring criminal prosecutions or take other enforcement actions. Now, let me say straight away, as things turned out, there was in fact no dispute between the parties as to the legal approach to the meaning of the exception. That's actually set out in paragraphs 60 to 65 before the conclusion section. So that tells you what the agreed principles of approach are, and the conclusion section itself, starting at 66, emphasises that there was no dispute between them, no issue as regarding the proper interpretation of the exception. The end of the paragraph explains that applying that test to the facts may not have been straightforward, but the court was not asked, nor could it properly have been asked, to decide whether a particular organisation, as a matter of fact, fell within the exception. So the result was it wasn't appropriate to make a declaration because there was no dispute. That's paragraph 67. But of course that obviously also had the consequence that there was no legal uncertainty as to the test to be applied. So the government couldn't rely on that perceived lack of certainty as to the legal test as justifying why it wasn't enforcing the law. In fact, they ought to get on and do it. And that's the substance of paragraph 68. So one might view the applicant as getting what they wanted, even though no declaration was formally granted. The agreed legal approach that emerged from the hearing was something that the Secretary of State was told to get on and enforce, even if applying it to particular facts wasn't straightforward. And that's the result of what happened. And my friend has marked as key to his submissions a passage back on page 174. It's actually part of the section that begins at the foot of page 177, setting out principles as to declaratory relief. And the section starts, this is into page 173, by setting out that there must be a dispute. That's as we see from paragraphs 39 and 40. There must be a dispute. And the passage my friend has marked starts on at para 43. So that's actually halfway through the discussion of the first principle, which is the need for a dispute. And we see the specific focus here is as to declarations where there's a real dispute, albeit not relating to a specific set of existing facts. That's not this case. That's what they're talking about, and that gives rise to particular difficulties, and it obviously arose in this transport case, nothing like our case. And the passage goes on at para 44 to identify relevant considerations, making 3 points, including pointing out a declaration is less likely to be appropriate where the question is fact sensitive. Lord Justice Leggett makes the obvious point that it's imprudent and less likely to be useful to give a ruling without having all the relevant facts of an actual case. Nothing like this case. In fact, my lords and my lady will have grasped that one of the points my friend suggested is that the declaratory relief the court should consider granting shouldn't relate to specific facts that pertain to the individual complaints in our case at all. So this is rather against him on that particular issue. Now another consideration, this is paragraph 45 of the judgment, is about ensuring all relevant sides of the argument are being put. So where others will be affected, that's a consideration. Again, nothing to do with our situation. And the last point, paragraph 46, is whether there's a better or more effective way of resolving the issue. That's all on the need for a dispute to be resolved. Now, the second key principle is turned to at paragraph 47, and this touches on the issue we've looked at in Rourke, and that's the division between the civil and the criminal courts in our legal system, such that generally a civil court should only grant a declaration that a particular conduct would or would not be contrary to the criminal law if there's a cogent reason for it. And his lordship says at the end of paragraph 47, all other things being equal, questions of criminal law are most appropriately decided by the criminal courts. Of course, contempt of court is quasi-criminal, but a point that I've already foreshadowed a few minutes ago, in terms of the split between criminal and civil courts, which this passage focuses on, it lies on the civil court side of that split. Now, the final marked paragraph, paragraph 48, is just more on that topic, explaining that it would be wrong to express an opinion on whether any organisation has operated in a way that constitutes a criminal offence, not just because they were not a party to those proceedings, but because that would usurp the role of the criminal courts. Neither of those points apply to our case. The only affected parties are parties to the proceedings, and there is no usurpation of criminal court's role in this case whatsoever. Even if, which I have already said isn't the case, even if there was any prospect of contempt proceedings for the acts in the past, but there isn't. So that's it on the cases that my friend bothered to put in the bundle from that plethora of cases in his paragraph 24 and 25, and none of them help you at all in my submission, and he doesn't get any further help from taking you through the case that he took you through, the Tester case this morning, just showing the general approach to when a declaration is appropriate either. Now, I was going to move on to address what are said to be the errors that the judge made as part of ground one. I can make a start, but I can see from the time that...
Can I just ask you for clarification of one thing?
Certainly.
Paragraph 9 of your skeleton, you say that indeed Merck Global expressly undertook not to bring contempt proceedings in respect of particular acts, etc.
Yes.
It's the last paragraph. That seems to me that might be putting it a bit high. Doesn't seem to me you did give an undertaking, did you?
Right, I thought it certainly says here it's recorded in the recitals. I thought we had, but
in tab 4, you did give an undertaking to the court, but it seems that on this point you just confirmed the court.
right.
I'm just wondering what the difference is, why you didn't give an undertaking.
Probably because it was understood that it was just never going to happen, but I thought that we had. But if formally we haven't done so, we're perfectly happy to offer that. I thought we had, and it was never been suggested that we were going to go behind it.
But I can see that once you've confirmed you're not going to,
Yeah,
it will probably be very difficult for you to persuade a court
exactly.
to entertain it.
I understand
but I
the
don't
point.
think you have actually given an undertaking.
Well, I certainly don't want to misrepresent. If I haven't formally given it, I thought we had, and we will do if my lords and my lady would accept it now. But we certainly have made it absolutely clear that we have no intention.
Yeah, well, I think that's absolutely clear. I just wanted to understand exactly what the status of your statement to the court was.
Yes, well, I have to say we thought we had, and it's in the recital to the order. But if it's not clear enough that it's a formal court undertaking, we're happy to sort that out.
Very good. Well, in that case, let's pause there and resume tomorrow at 10:30.